To thank everyone for attending today. This is the Mason City Employers Council of Iowa seminar on Family and Medical Leave Act. We are very grateful to be able to have Tom Phelan join us today. He's an investigator and has been an investigator with the U.S. Department of Labor and Wage Division since 1988. We're grateful for his wealth of knowledge and being able to come and chat with us today. In the chat, you'll see a couple of items. One is the Sherman HRCI credits for attending today's seminar are available there, the codes, as well as a document that Tom has shared with us, the ABCs of FMLA. So you can click on that link and it's kind of a guide for some of the information he'll be talking about today as well. With that being said, I'll turn the time over to Tom now. And
thank you.
Also if you would like to ask any questions, feel free to plug those into the chat as well. And Tom will be answering those throughout the seminar today.
Thanks, Todd. My name is Tom Phelan. I'm a federal investigator. I work for the United States Department of Labor Wage and Hour Division. I'm very pleased to have this opportunity to visit with you today. And I would like to see this, if possible, if we could have this as a dialogue, as far as, yes, I do have a PowerPoint, and yes, I am going to be running through a lot of slides there. But if we have questions as we go along, because FMLA has a lot of nuances, a lot of people have heard about it. I mean, it's been around for 25 plus years and have passing knowledge of it, but it's the nuances that sometimes people go, what? Hmm? And I asked Todd for permission to, number one, at the top of the hour, let's take a 5-minute break so that you can answer those texts that come in or emails that need your attention right now. Go to the bathroom, grab a snack, whatever. And then also I've asked Todd to just click for me the PowerPoint presentation itself. It's just one less thing for me to pay attention to because I got all these monitors going. Plus I have paper copies too, because in case you ask me a question and maybe I don't know the answer, well, I know where to go look. And to facilitate, where does one go look? I asked them to provide to you a roadmap. Now, when I say the ABCs, in FMLA, there's really part A, part B, part C, all the way up to H. And we're not going to cover everything. We're just going to cover the really important stuff on FMLA, things that might engender conversation and a dialogue. And I'm a public servant here. And so therefore I am here to serve. And if you look at the mission statement of the Department of Labor, it's to promote and to achieve compliance with labor standards that protect and enhance the welfare of the nation's workforce. So the law we're going to talk about today, the Family Medical Leave Act, is a perfect example of one of the laws enforced by us. You may have better passing knowledge with us concerning the Fair Labor Standards Act, or if you're engaged in construction on federal finance construction projects, Davis-Bacon. If you're in agriculture, H-2A, Migrant Seasonal Worker Protection Act. There's a lot of different laws that we enforce. And should we have time at the end of our hour and a half, and you have some questions that don't pertain to FMLA, but still, while you got a federal investigator right here or earshot, let's talk about that, okay? So number one, we've just gone through a global pandemic. The Department of Labor, like many employers, was doing things remotely. And we found, first of all, that we could do things remotely. And now that we're emerging from this pandemic, our focus has always been on protecting the workforce and supporting essential workers who continue to keep the economy running. But let's first talk a little bit about where we're at right now, where we're going. Our first, on the next slide here, it's more of a disclaimer, which is that the Department of Labor enforces all of the labor laws, regardless of immigration status. And we don't ask about your immigration status. It's not relevant to any of the laws that we enforce. Okay. Now, in the next slide, where we're going to be talking about compliance, keep in mind our standard, we're not a gotcha agency. We're not always doing investigation. In fact, an ounce of precaution is worth a pound of cure. So if we can educate employers as well as employees as to their rights and responsibility, win-win for everybody. So we view compliance assistance as a critical element of our task to protect the nation's workforce. Last year alone, our agency did over 4,600 outreach opportunities. And now that we've seen how the pandemic works and doing it remote, we may be able to do a lot more than in the past where we were doing that in person, where we would travel to the site and employers would travel to the site. So what we look at here in the next slide is the, when we talk about essential workers, the Department of Labor has always focused on, we use various words, vulnerable worker, low wage worker, but we look at metrics, we keep track statistics, and we go to those industries that have lower levels of compliance, or sometimes to those industries that have lower levels of compliance, as well as workers simply won't file a complaint. An example of that would be in agriculture, and that could be for lots of reasons, but the biggest one is they don't know better. So these are the agents, the essential workers who continue to go to work during the pandemic, who were showing up. And so these are the essential workers that, for the most part, we've always been doing them, but we've continued to do so during the pandemic. Now, in the next slide, where we talk about the risk that low wage or essential workers run. When we talk about low wage, oftentimes what it is, under the Fair Labor Standards Act, which is the minimum wage and overtime law, if there are problems going on there that causes a minimum wage underpayment, such as improper deductions for meal breaks that they don't actually take, or deductions for uniforms, or charging employees for mistakes, errors, breakage. The FLSA itself does not prohibit deductions. It does, however, place an affirmative responsibility to pay no less than the minimum wage or overtime, as the case may be. Now, state laws vary from state to state, and you should always check with the state that you're in to see if there is a state law that limits or regulates deductions themselves, but we address it if it causes a minimum wage or an overtime underpayment. One area that can cause problems when low wage people, well, really, even high wage people, is not paying them for all hours worked, which itself could be a separate seminar that we could talk about as what our hours work. But if you work off the clock, that could be pre-shift time. You have to come and first turn on your computer and get everything going, or you have to first set up your work area, or the restaurant, they have to set up or stock. Also post-shift time, if they have to be out by a certain period of time and the employees clock out but continue to work. If the employer has knowledge or should have knowledge, they cannot turn a blind eye to that. So that's off the clock work. Misclassification is another area that we look at, and that is oftentimes where employees, there is an employment relationship, employees do not own their own, they're not an independent subcontractor. They don't own their own business. They don't hold themselves out to the general public. There is no opportunity for profit and loss. They're an integral part of the employer's business. They're economically dependent upon the employer. We have a fact sheet that addresses employment relationship. That's fact sheet 13. And of course, the IRS has a far more. That identifies the 7 criteria that the Department of Labor looks at. The IRS has 20 different criteria that they look at, but you'd have to go to their website for that. And the Supreme Court has been very clear on this, is that no one factor is controlling. All of them have to be taken in their totality. So misclassification is a continued area that we've had to grapple with here. And then finally, when we're talking about the denial of leave, we're talking there about Family Medical Leave Act. And oftentimes when that occurs, it's because the employer doesn't understand or know better. Now, in the next slide, where we talk about the various different laws that we enforce, we've already talked about the Fair Labor Standards Act, which is the minimum wage, overtime, record keeping, and child labor law. We also are going to be talking about the Family and Medical Leave Act. That's the third bullet there. The Migrant Seasonal Worker Protection Act, as well as the H-2A provisions of the Immigration Nationality Act, addresses farm workers and protections for them. Payment of prevailing wage, that's oftentimes referred to as Davis-Bacon, but that's payment of prevailing wage and the prevailing wage practice on a government finance construction project, which itself could be its own seminar. And we're not really going to have any further discussion about it unless at the end you have a question or two about that. And then H-2A and H-2B, those are for low skills visas. Those are guest worker programs that the Department of Labor oversees. So in the next slide, where we talk about, and I have paper versions of these so I can keep track where we're at here. So we're going to talk now, segue over to the Family Medical Leave Act, okay? And in the Family Medical Leave Act here, in the next slide, next one here, family is so that the employee doesn't have to make a decision as to whether I'm a good employee or a good spouse, a good parent, a good child. They can be both, is what that recognition is here. So in FMLA, in the next slide here, FMLA itself is unpaid leave, and it is 12 weeks of unpaid leave. It's a job protection law is what it is. And it's to protect the job that the employee has at the commencement of the leave, so that when the employee returns back, the equivalent pay, position, shift, location, everything that existed beforehand is given back to the employee. Okay, so in the next slide here. Okay, so we're just going to go on to the next slide here, which has a disclaimer here. In the disclaimer, you ever watch the nightly news and how they'll have those drug ads on there, and then at the very end of the ad they have a list of disclaimers, and I always kind of like, wow. Well, I'm not going to do that. All I want to clarify here is that I don't know all the answers. Yes, I've been a federal investigator for decades. Yes, I was around when this law was created. I have a very extensive working knowledge of this law, but I don't know everything. But I'll tell you where the answer is. It's right here in Regulation 825, and that's the reason why I gave you a roadmap. The roadmap is so that if you need to go and I put a hyperlink here as to that, but also the roadmap tells you where they're at. And then on the second page or the back of the page, I identified, I just did a copy and paste of all of the fact sheets that we have, as well as the forms. And I'll be referring to these forms throughout this. So in the next slide here, okay. The purpose, the point of FMLA is, again, so that you can be both a good employee as well as a good immediate family member. We'll talk about that a little bit. But here what's important is that there must be communication going on between the employer as well as the employee, as far as they have to, although they don't have to necessarily invoke FMLA, they have to give you requisite knowledge of the need. They're not showing up to work, and why are they not showing up to work? And so that you can make a determination as to whether or not they are eligible for FMLA, and then advise the employee of their rights and responsibilities. And we'll talk about that in just a little bit here. I think we also had a little taste of this recently during the pandemic, when we had the law called the Family First Coronavirus Response Act, which was a paid 2-week sick leave. And it was referenced into FMLA, although it was its own law. And that law itself expired at the end of the pandemic year of 2020, December 31st. There is a 2-year statute of limitations under it, just like there is under the FLSA. So if you were denied under the Family First Coronavirus Response Act, the 2-week paid vacation, and it was otherwise applicable, it's not too late. You could still file a complaint with us and we would look into it, because not every employer was subject to this. It was for employers with less than 500. And then there were some other criteria that needed to be met. So if you have questions about that itself, we'll talk about that later on if you haven't, but if not, we'll just move right along. So in the next slide, where we talk about why, the so what factor, which is we want to talk about it up front, is it works. And I think we're seeing more and more of this as far as employees, they're looking for a balance here, and they don't want to have to fear losing their job while taking care of sick family members here. This first quote itself we pulled out, and that was from the Secretary of Labor, Harris. And then the second bullet, that quote was from the Wage and Hour Deputy Administrator, Mary Beth Maxwell. She's no longer our Deputy Administrator, but this was from the past. And we just pulled that out because we thought that they said it so well. Very good. Okay. So now let's talk about coverage in the next slide. Coverage is who has to pay attention. Okay. Coverage applies to employers. All right. So in the next slide, where we talk about coverage, Todd, can we go on to the next one? Thank you. There we go. Okay. So not every employee is covered. Not every employer is covered under the Family Medical Leave Act. Not every employee is eligible, and we're going to talk about that separately. Coverage itself, that just applies to employers. So if you're a private sector employer that has 50 or more employees within 20 calendar weeks, either of this year or the year before, then you would be subject to it. And when we say 50 employees, okay, it doesn't all have to be at one site. All right. Also, public public agencies, they're subject to FMLA, and also so too are schools, both private and public. Okay, so employee eligibility, and these were the topics we're going to be talking about those here. Okay, we talked about coverage, and now let's go on to employee eligibility. Which, let me see, I'm cheating. I'm 2 slides ahead of you. Sorry about that. At the beginning, I brought Todd this. It's a plaque that I have from home, but basically it's to remind myself that if I can laugh at myself, I have a constant source of amusement, and golly gee, I'm always laughing at myself. So let's go on to the next slide about employee eligibility. And next one, there we go. Okay, so first of all, you have to be working for an employer who is subject to the law. And then you have to have worked for 12 months, and they do not have to be consecutive 12 months. They could have been working there during college and then a summertime job, for example. So at face value, you have an employee who maybe has 10 months. And at first blush, it looks like maybe they're not subject to it. But you also have to consider if they've worked for you in the past. And then also, they have to have worked at least 1,250 hours. Keep in mind that with FMLA, it's for if people are sick. So if the employee themselves are sick, they may not be a full-time employee. Generally, the rule of thumb is 24 hours or more, you can get up to that 1,250 hours. That's kind of a quick and dirty rule of thumb. And then you have to be working at a job site with 50 or more employees employed within 75-mile radius of that. And that 75-mile radius as the crow flies. I typically, it's real easy to make that determination. But for example, I'm in Omaha, and if they were in Clarinda and you had a site, the person in Clarinda, they don't have the 50 employee count, but the Omaha, if you add those two together, they would add up to. Okay. All right. So now, in the next slide here, tell me, is there anyone here among the audience who works for the airlines or is an airline employer? If you are, just put it in the chat and I'll stop and spend a little bit of time as we go along. Because the FMLA was changed to include these employees. But if we don't have anyone that's subject to it, I'm just going to just slide on by, and either the citation.
Nothing in the chat so far, Tom.
Okay, excellent. Okay. Before I move on, anyone have a question about coverage or employee eligibility? And you can put it in the chat, you can raise a hand, or you can just orally ask the question if you do. Okay, well, good. Well, let's move on. And let's talk about qualifying reasons. Okay. So FMLA is for one of the qualifying reasons is for the birth or placement of a child for adoption. Okay. To care for a spouse, son, daughter, or parent with a serious health condition. If the employee themselves has a serious health condition. And then we kind of put it in on the slide here, the military family leave, because that's its own little caveat, so to speak. It has its own criterion there, and we'll spend some time about that later on, okay? So let's move on to the next slide. Okay, well, a parent here, what this means when we talk about that is not only are we referring to the biological parents, or if there's a legal relationship, they've adopted the child, or they're a foster parent, stepchild, etc. But they use the Latin word, which is in Loco Parentes, which means an individual who stands in the role of a mother or a father. So if that is such a person, even if there is not a legal relationship between them, for example, they have not actually adopted the individual, the child, they still could qualify for this. A spouse is the husband or wife, or if the state law recognizes common law marriages, it also includes same-sex, because that's now, because of the Supreme Court ruling, most states do recognize that now. Then when we talk about son and daughter, there is also son and daughter, they discuss that in more detail about the military leave, but in general, it's for minors under the age of 18, though it can be taken for minors over the age of 18 who need assistance with activities of daily living as defined under the ADA, which if you have questions about that, we can talk about that a little bit more, but they would need in part of the certification if they're no longer a minor, they're over the age of 18, then the parent could still take FMLA for that person to provide that assistance, okay? Okay, so in the next one here, we're gonna start breaking these down a little bit more as to, it's not just when you have the baby, the time actually having the baby, obviously, but also any prenatal care. And then also FMLA is commonly used for after the birth of the child. And if this is a healthy child, there are no medical issues or concerns, praise the Lord. However, they're taking time to bond with the child, the mother or the father. It makes no difference as to how they do that. And frequently you'll have one parent take a block of time from their employer, and then the other parent takes a block of time from their employer. Okay. The time that they take to bond with a child, now we're not talking about the baby might be sick, but the time to bond with the child, they have to do that within 12 months of the birth of the child. Okay. Okay. So now we move on to the next slide, which talks about a serious health condition. And in FMLA, they actually define a serious health condition, and that's defined in 825.113. But in this one here, a serious health condition, okay, so we're going to walk you through each one of these, but it's the illness, an injury, an impairment that left untreated could lead to a serious health condition. And it could be both physical as well as a mental condition, a mental health condition, depression, for example. It's for both inpatient, that meaning in the hospital overnight, or for continuing treatment by a healthcare provider. So in the next slide, where we talk about inpatient, so they're staying in the hospital overnight. So you have an employee who calls you, or their spouse or significant other, somebody's calling you and they're telling you that the employee is unable to report to work because he's in the hospital. That should set off a red flag to you. Okay, FMLA, maybe FMLA is applicable here. And then, so they go into the hospital, and let's just say heart attack, stroke. I mean, something real common. I mean, like not common, but it's so self-evident that it's FMLA. But it's not only for that time that they were off while in the hospital, but for any related periods of incapacity or for treatment that they're providing for that. Any questions right now? No?
Nothing popping up in the chat yet. Just a reminder, if you have questions throughout the presentation, just feel free to plug those in the chat and we'll let Tom know so he can answer those for you.
Yeah, the reason why I'm encouraging questions as we go along is that I'm the type of person, squirrel, and my mind's off. So rather than to wait till the end, if you have a question while we're talking about it, let's stop and talk about it right here and now, okay? So now the next one where we're going to talk about continuing treatment. This one here is not only the period of time that they took off for the serious health condition, but also for ongoing treatment. They may have follow-up visits on that. And then continuing treatment is where they park the pregnancy and the birth of a child with their chronic conditions. We'll talk about that in a little more detail. And then for permanent long-term conditions and with absences that have multiple treatments as they go along there. Okay. Okay. Now, when we talk about this, okay, I'm sorry. When we talk about a healthcare provider, okay, doctors, mental health people, anyone that the insurance program would accept as a healthcare provider, it can include podiatrists or dentists or clinical psychiatrists, chiropractors, if the insurance program recognizes that, clinical social workers. It also includes Christian Science practitioners. Yeah, I'm trying to think of who else it might include, but if they're a healthcare practitioner and they're authorized to practice here in the United States, then they're the ones who make the determination as to whether it is a serious health condition. It is not the Department of Labor that makes that determination, nor frankly does the employer or the employee. It is a healthcare provider who makes that determination. So when we talk about continuing treatment by a healthcare provider, and that's why I kind of went off on a tangent. What is a healthcare provider? We're talking about treatments where 2 or more times, both of these visits have to occur within the first 30 days from when they first have the incident that they're taken off. And then if there's an ongoing regimen of treatment, then that would kick in there too. Okay. Okay, any questions? All right, and go forward one more. We went back one more forward. Okay. Yeah, chronic conditions, exactly. So with a chronic condition, there are some things that they're not going to see the doctor on a regular basis because it's a chronic condition, such as asthma, diabetes. I've seen migraines in here. These are examples where they don't have to necessarily go to the healthcare provider because they have a chronic condition and it has been so certified, but they're having a flare-up from that, so that it lasts over an extended period of time, but they're episodic in their flare-ups, as opposed to just a continuing period of incapacity or that has subsequent visits from them. Okay. So in the next slide, on periods of incapacity due to a permanent or long-term condition, examples of that could be a stroke. My father had a stroke, and I used FMLA for that, and I was grateful for FMLA. My father had a stroke. We were at the hospital overnight. The next day, when we looked, okay, he's out of the woods, I took my mother home. We're on the phone talking to my brother in California. My mother has a heart attack while on the phone. So of course I call 911. We go back to the exact same emergency room that we were in, and it was even the same staff. It was just like, what are you doing here? So I had 2 parents, each of them with their own serious health condition, and I was working for a covered employer because it's a public sector employer, and I use FMLA. So that's why I had a firsthand experience with FMLA, and it's endeared itself to my heart. So on a permanent long-term period of, this is where they're under the continuing supervision, but they don't necessarily receiving active treatment by the healthcare provider. An example of that could be Alzheimer's or cancer. So any questions about that? Okay, so in the next slide, where we talk about multiple treatments, this could be for a restorative surgery. If left untreated, would likely result in a period of incapacity. And it could also be applicable to chemotherapy. That's another one, or severe arthritis could be some other examples of that one there. So that's just further examples where you're receiving multiple treatments, but it all relates back to a serious health condition that has been so certified. Okay. So now in the next slide here, the amount of the leave. Now, before I move on, were there any questions about serious health conditions that somebody was wondering in the back of their mind, or a fact pattern that baffled them in the past or something? Okay, all right. So FMLA itself is for 12 weeks, and it's a job protection law, as we mentioned earlier. And as we mentioned, it's for a serious health condition of either the employee or an immediate family member. When I say immediate family member, I mean their spouse or their child. It does not apply to in-laws. It doesn't apply to grandchildren or grandparents. It's for the immediate family member, and that's what that second bullet there is for. And then obviously if they're taking it for themselves, but it's for 12 weeks of job protection leave. So now in the next slide here, And unless
We have one question I can ask if you want.
yes.
So the question is, if someone is out for a serious health condition but does not seek medical attention until after the initial 7 days, would that cause their FMLA claim to be denied?
Here the courts have always looked at the actual fact pattern itself. And if in fact it is a serious health condition and due to either the employee was unable to, or simply due to lack of knowledge and they were unable to act on that, then no. If it is still in fact a serious health condition, then it would kick in. And the same goes as far as notifications, which we're going to cover in a little bit, as far as failure to give proper notice or the employee not asking for FMLA does not negate their rights under FMLA. Okay. Okay. So in the next slide here, intermittent leave. Let's first back up a little bit, not back up in slides. FMLA is for 12 weeks of job protection. So if you work 5 days a week and you take off a day, it's 1/5 of that week, all right? Many employers will convert the 12 weeks of job protection to hours. If you have an employee that's working 40 hours a week, well, it's 12 times 40. If you had an employee that is working, scheduled to work 48 hours a week, well, then it'd be 12 times 48. So it's the fact pattern that determines that. And the reason why they do this is that intermittent leave is when an employee is taking off, but they're not taking a block of time off, nor are they taking a reduced schedule of time off, but they're taking it episodic on an as-need basis, all right? And so that's when the intermittent leave kicks in here. And of course, they've already applied for and been designated and granted the FMLA. They do need to be telling you about that as they're taking off. It's not just the hooky day that they're doing. There also could be where they're taking intermittent leave. When I think about this, adoption, you're going to adopt a child and you have to have a series of visits with the social worker, the adoption agency, etc. That's another example where you can be using intermittent leave. But usually it's being used for medical reasons or the doctor's appointments there, or because they have a flare up there. So when they're taking intermittent leave, and we'll talk about military leave later on. Here's the thing is the bottom thing when it's talking about there, that's where they're taking it off as a continuous block of time. The employer may grant intermittent leave, and that's for the bonding experience, but they're not obligated under FMLA. So once they return, the employee wouldn't be using intermittent leave there for the bonding experience, unless the employer is okay with it, okay? All right, now, in the next slide, and here, okay, we kind of reference this a little bit here, but they've reduced it to hours. But if their system permitted them to do it at lower increments of hours, such as by the quarter hour, they could charge the FMLA time down to the employer's lowest increment that it permits that. Under FMLA, an employer cannot require them to take off more time than what is necessary to address the circumstances. So for example, I'm using intermittent and I take off 3 hours, and the employer can't just make me take off 8 hours, unless that happens to be their lowest increment of time, which rarely have I ever seen that be so, okay? this bullet here, required overtime not worked, may be counted against FMLA entitlement. If a person was scheduled to work overtime, but they're working a reduced schedule for medical reasons, that only allows them by the doctor order to only work 40 hours. And let's just hypothetically say that the employee was scheduled to work 48 hours on a regular basis. Well, the 8 hours that they take off on the reduced counts against their FMLA leave usage. Conversely, in doing the math up front, if you're saying that they're scheduled to work 48 hours, well, you have to take the 12 times the 48. Okay, does that make sense, sir? Okay, and we're just gonna move right on as far as airline passengers. I'm not gonna spend time talking about that, okay? So let's talk about some special rules here. Physical impossibility. If the employee's use of leave on an intermittent or on a reduced leave, and it interferes with the start and end of their work time, and due to physical impossibility, the employee is absent, then all that time could be counted against them. Where I've seen this frequently is with the railroads, the trains, as far as the train's already left. So even though I only need a half day, I have to take off because I can't go because the train's already left. I work on the train itself, or I work on the plane, it's already left. Or if they're working at a biohazard location and they have a clean room and it only is, it only opens up during certain periods of time. And both of these examples, there is no equivalent position to offer to the employee, then yes, they could be required to take off that whole period of time due to the physical impossibility. Now, we as an agency, we only enforce this in the most limited circumstances, and it is the employer's burden of proof to prove that that's so. They can't just say it's an inconvenience. Okay. Now the next one, holidays. First of all, there is no federal law that requires holiday. Most employers offer that as a fringe benefit. But on holidays, and typically the 5 or 6 major holidays where they're closed, well, you wouldn't be charging them that time against them if you're already closed, unless the employee was using a block of time. For example, I've taken off 6 weeks of time to bond with my child. And within week number 4 is one of the holidays: Memorial Day, Labor Day, 4th of July, Christmas, Thanksgiving, where the facility is closed. In that scenario, it would still count the whole week because I took off 6 weeks. It would not be 5 weeks and 4/5. Okay, so that's the holidays. Sometimes it is, sometimes not, depends upon that. As far as
Tom,
yes,
we have a couple of questions. We want to get to those right now.
yeah,
First one is question about FMLA for a family member's serious health condition. If the family member of the employee is requesting leave is not an immediate family member, not a spouse, parent, or child, and there is no in loco relationship, that an employee has been granted legal power of attorney for healthcare decisions would this qualify for FMLA, provided that the serious health condition has been proven?
no, because they're not a spouse. It doesn't apply to siblings. I think is a scenario that I'm thinking about where I have power of attorney or power of attorney in medical matters for my twin brother, which I do. Okay. So no, they have to be a spouse, a child, or parent. And where I've seen it work grandparents, it doesn't apply to them. Okay, so outside of the immediate family, no, it's not applicable, even if they have a serious health condition. What's the next question?
Next one was, is there a responsibility of the employee to prove that their intermittent leave is for the approved leave? Migraines or internal issues or intestinal issues would be examples, I guess.
There would be, as far as the certification goes. But if they do have certification for a migraine, for example, they would not be required to go to the doctor. No, but up front, yes. Did that answer that person's question?
I'll see. Yep, that worked out.
Okay, all right. Now, particularly when they're using FMLA leave for an intermittent purpose, the employee, and it's a planned medical treatment, the employee is responsible for scheduling the leaves so as to not unduly disrupt the employer's operation. I mean, sometimes there are scenarios where it's beyond the control of the employee as to the timing as to when they can get the medical appointment, but they should try to schedule their appointments so that beginning of day, end of day, so that it's not right during the rush. And it talks about that in the FMLA reg itself. The citation is at 203 and at 302E, where it talks about that. And let's see. Also, I failed to mention this earlier, is that there's two different types of FMLA leave that can be happening: a foreseeable event and an unforeseeable event. If it is a foreseeable event, the employee must give the employer a 30-day advance notice. And then, as we talked about, schedule it to accommodate the employer. But if it's an unforeseeable event, then as soon as possible is when they need to give the leave notice. Okay. So any other questions here? Oh, transfer to an alternate position. That would be where you're trying to keep the terms and conditions as similar as possible, but you're putting them in an alternative position and offering this to the employee. And it is the assumption here that both the employee and the employer are communicating with each other, and they both want what is best for each other here. Okay, so you transfer them to an alternative position that better accommodates the use of leave that they're taking. It could be a reduced leave, intermittent leave, etc. Okay, but what you would want to be cautious of is if you transfer them to a different shift or to a different location. An argument could be made that you're trying to make it really difficult for the employee to utilize their rights under the family medical leave, and therefore discriminatory in practice. So that's something where work with the employee on that. But the assumption is basically it's same shift, same pay. The responsibilities may be different because they're doing a different position, but same location. As much as possible, you keep it the same. Okay. Now this other one, the rules here is special rules apply limited to spouses. Both the husband and the wife are working together for the same employer. And this is where you'll see it more frequently being used with birth of a child. One cannot take off and that's the event itself. So it's 12 weeks maximum combined between the two of them. So if one parent took 7 weeks, 8 weeks, then the other parent could only take, and let's just say 8 weeks, the other parent could only take 4 weeks. And that would be the best example I can give is the birth of a child there. Okay. Now, both parents work for the same employer. They took time off to bond with the child, but if the child has a serious health condition, that's a different event. Or if either one of them has a serious health condition. So each parent still has 12 weeks. You can have multiple reasons, multiple certifications going on here. Okay, so let's move on right along now. Okay. And, all right, so here, and this one here, where I put in the roadmap here, that's in 200, 825-200, where you have that here. All right. I'm going to walk you through each one of these separately, and then I'll tell you what I most frequently see when I do a compliance review. An employer can use a calendar year, begin on January 1st, end on December 31st, or they could use a fiscal year, but they use a set 12 months, okay? And then the other one, they call it the rolling forward method, where it commences at the time that you first take leave, then you're counting the 12 weeks rolling forward. You could also do the same looking back. All right. So I guess an example of that was state of Nebraska. If you get speeding tickets, I think if you get more than 12 points, you could lose your license. So you got to be careful. But if it's beyond a certain period of time, they drop off. The same goes here with FMLA. Let's say that the one that I most frequently see is they'll begin it and they roll it forward in the 12 weeks. But it also, if you think about it mathematically, it's dropping off behind there. So the reason why the vast majority of employers choose, and it is their choice, not to use a fixed unit of time, let's just say a calendar year, or it could be a fiscal year, as I mentioned, is that I become vested for 12 weeks of job protection on January 1st. I begin taking FMLA the middle of October, okay? So by December 31st, I've used 2.5 months. Then on January 1st, I get another 12 weeks. So this would result in an employer being obligated to hold that job position for longer than 12 weeks. That's the reason why the vast majority of employers choose not to utilize that methodology. Okay. All right. So
we have one question popped up.
Yes.
The question is, so each event certification is 12 weeks, or was that just an explanation if there are issues for husband and wife for a certain block of time?
No, 12 weeks from when they first begin the first certification. They can't, the job protection of FMLA will only apply for up to 12 weeks. And if they exceed that 12 weeks, then FMLA no longer applies, and the employer can then proceed to use their normal policies, which of course you'd want to make sure that they're compliant with ADA. But their attendance policies could be counted against the person, and if it resulted in the employee losing their job after 12 weeks have expired. So the question that the person was asking is, with each certification, do I get an additional 12 weeks? No, the maximum amount of time that you get is 12 weeks. What I believe I've confused the participant is that I wanted to convey that you could have multiple certifications going on, in that I myself might have certification for a serious health condition, and then my spouse, I have to take time, or my child, I have to take time off for that. I still only have the 12 weeks. Okay. All right. And
sounds like you emphasized that too. There's the next question that came in was, is that 12 weeks per event though, or is it total regardless of multiple circumstances?
The second one. But if you think about this, because of this limitation of job protection to 12 weeks, that's the reason why many parents choose not to use the full 12 weeks of FMLA job protection with the bonding of their child. That's a decision made by the employee, okay? But many employees choose not to because just in case something happens, then they're out of FMLA protection. So that's a choice of the employee though, okay? All right. Any other questions? All right, so now we're going to move on to substitution of paid leave here. Paid leave is a fringe benefit. It's not required by the law, with the exceptions of the Family First Coronavirus Response Act, which has expired. Okay, that was the first time that there was that. Or Davis-Bacon, that's a different law, etc. But in general, paid time off, vacation pay, sick pay, these are all fringe benefits. And whatever contractual obligations the employer enters, they should follow them because they're the ones who set the rules in the first place. Now, an employer, because they're not required to give paid sick leave, may have a rule where you have to first exhaust your paid leave within the 12 weeks of job protection. FMLA itself is unpaid protection. But if I have a rule that I have to first use my accrued vacation time or my accrued sick time, as long as it's a uniformly applied rule, they can do that. So I might have in the bank 3 weeks of sick leave. The employer would use that 3 weeks of sick leave, and then I still have 9 weeks of FMLA job protection. What I don't have is I'm going to use my 3 weeks of sick leave, plus I'm going to use 12 weeks of FMLA, adding up to 15 weeks. No, 12 weeks is 12 weeks. Okay. Let's see. So yeah, we've covered that slide. Good. Okay. All right, so we'll move right along to the next one, unless there's a question about that. And this is a thought just came into my mind. Workers' comp. Okay. Let's just say that they were injured on the job and you know about it and it's running concurrent. It's not, they're not mutually exclusive. The injury that the person is off work and collecting workers' comp, you know about it, okay? So it's running simultaneously with the FMLA job protection, not independent of that. It's not sitting out there. They're running simultaneously. Okay. Now we'll go on to the next one. Well, I guess I was getting ahead of myself there. Okay. So disability leave, it too runs concurrent because we already talked about workers' comp. All right. Compensatory time. If you work for a public sector employer, under the FLSA, public sector employers may use comp time. Comp time is for every 1 hour of overtime worked, I get an hour and a half off at a later point. It is never an hour for hour trade. So comp time, and it's only allowed to public sector employers, not in the private sector. But they may require you to use your accrued comp time while on FMLA, and it counts against it. Okay. Okay. Let's move
One
on.
question, Tom.
Yes.
We have someone that is getting checks from work comp and is on FMLA. She is getting checks from work comp since she doesn't have any sick time to use. She is back to work today on light duty. So she's done with her FMLA, right?
She might be using, yes, if she's back to work, but there could potentially be a reduced leave where they were working overtime and now they're limited to only working 40 hours a week. Then you have a reduced leave. But yes, they're off duty. They're off FMLA because she's back to work in that fact pattern being specified. Okay. So we're going to talk about employer responsibilities, and then we're going to talk about employee responsibilities, because again, the two do match in. There is a question on the agenda here as to paperwork deadlines, and I will be covering that in these slides that are yet to come. And the whole point of FMLA is that it's a job protection law. So we're going to talk about the employees' restoration rights, and we're going to talk about key employees, who's a carved out area. And we'll talk about that a little bit too. And as far as maintaining records, we're going to talk about that. So in the next slide, where we talk about the employer general notice, the general notice is, and that would be the next one. Yeah, here we go here. Where I'm seeing this is electronically, this is being kept. If you have an employee handbook, then yes, of course, that too. But sometimes the handbook, most of the time nowadays, the handbook itself is maintained electronically. And what many employers do is they just use the FMLA fact sheet from the Department of Labor itself. You can, you don't have to use that. You can create your own. And when I do a compliance review under FMLA, I'm always looking at the employer's policies to see if I see any deficiencies there that may be applicable there. The language, if your dominant workforce is Spanish speaking, for example, you would also be obligated to have that in the language that they would understand. When we talk about CMPs for willful posting, that would be, there's a reason why you're not. CMPs is an option under the Family Medical Leave Act, but it is rarely used. Just as liquidated damages are an option under the Family Medical Leave Act, it is a remedy, and that's when lost wages have occurred. But rarely is it the Department of Labor that seeks liquidated damages. In a private action civil suit, an employee may seek liquidated damages. So if I do lost wages of $3,000, I would ask the court not only to award me that $3,000 in lost wages, but also $3,000 in liquidated damages. Whereas civil monetary penalties, those are punitive, and those go to the government, not to the employee. Liquidated damages are not viewed as punitive. Liquidated damages are viewed as compensatory. All right, so let's move right along to provide notice to the employee. And here's one of the answers. We're going to cover some of the other ones here. It's the time frame. Let's move to the next slide. Here we go. Within 5 business days of the leave request, or when we say knowledge that the leave may be FMLA qualifying, because the employee doesn't have to necessarily invoke FMLA for it to be FMLA. But if they give you, we call it requisite information, but the employee or somebody acting on their behalf has given you information that the employee is not reporting to work, and they're giving you enough information to send up a red flag. They're in the hospital, or they've missed more than 3 days of work so far, and it's due to an illness. Not all illness is serious health conditions. The flu is not. It could become one, but typically it is not. So they're giving you information and they're not showing up to work. And so you need to be asking questions, okay? The eligibility determination, they don't have to do it every time that they use FMLA. It's just at the very beginning as to whether or not they're eligible. And the eligibility criteria, remember we talked about, they have to have worked at least 12 months. And in the past 12 months, the 1,250 hours. The new notice for subsequent qualifying, that's if they have an additional certification going on for yet another serious health condition, which does sometimes happen, okay? When you tell them about their eligibility here, okay, you have to, if they're not eligible, you have to tell them why they're not eligible, all right? For example, that you do not have the 1,250 hours. When FMLA was first created, the Department of Labor understood and interpreted and enforced the law that once you were eligible, you remained eligible. The post office challenged us on that because they had scenarios where an employee did at one time meet the 1,250 hours, but they no longer did on an annual basis, and they looked back and they no longer met that criterion. The post office denied them because their argument was, well, it's right there in the regulations that says that. The courts agreed with the post office. So we refer to this as the Runyon decision because he was the postmaster at the time. But really when they codified, when they rewrote the FMLA, and that happened in 2013, it's now in the regulation itself. So there is no longer that ambiguity. It's very clear there as to that. So if they're not, you have to tell them why they're not. Even though it may be oral, it's recommended, highly recommended that you put it in writing, and you may use our forms. In the back, got hyperlinks to it. So when I say 381, the 381 is the notice to them of their eligibility, okay? And that's where, at that same time, you're also going to advise them of their rights and responsibilities, okay? So now in the next slide here, where we talk about their rights and responsibilities, you, the employer, make a determination within 5 days that we talked about of whether or not they're eligible. And when they rewrote the regulation in 2013, they really codified and put it right in there, the 5 days. And that was because prior to that, there had been some large employers that would sit on it as far as the employee would request the time and they just didn't respond. So this was to push it, to get them to respond, all right? So it has to be in writing as far as when you're telling them their rights and responsibilities. And these are the criteria that should be included in this, okay? If you're going to substitute the leave with paid leave, tell them that. If you're going to require a fitness for duty to return, tell them that. Let's see, arrangements for premium payments. Oh, insurance payments, that's what that's about, okay? How are you going to handle that? Because the employee, if you're substituting paid leave in the 12 weeks, well, you have something to pull the insurance premium out. When I say the insurance premium, I'm talking about the employee's share of the insurance premium, not the combined, but just whatever the employee would have paid beforehand. But if they're on unpaid leave and there's nothing to pull it out, you have to make arrangements with the employee as to how that will be handled, okay? And then if they're a key employee, and I'm going to cover this in a slide a little bit later on, but a key employee is top 10% salaried employee, management level, top 10% salaried employee, and that we'll cover that in a later slide as to why you don't have to offer them the job restoration, because you have to hire somebody to be running the business operation while they're gone, okay? And we'll talk about that in just a little bit, okay? And then also you tell them in writing as to their job restoration rights and the maintenance of fringe benefits. So in the next slide here, okay, that would be provide notice of designation, okay. So here, what we're talking about here on notice of designation, that has to do with the military and the entitlements, okay? And you tell them, we went the wrong way, didn't we? I know. Oh, okay. No, you're in the right spot. I'm in the wrong spot. Okay. So you're telling them exactly what is the FMLA, what's being the 382, which is the recommended form. You don't have to use our form, but you can't have requirements higher than what's already in the FMLA itself, I guess is a better way of saying that. Most employers, why reinvent the wheel? They just use our form, but you don't have to use our form. And you have to tell them again, if it's not going to be FMLA qualifying, why, okay? When you give them notice of designation, you also, if the certification itself is lacking, you have to give them an opportunity to address that, okay? And I think that's going to be covered here in the next one, the next slides. Next slide. Okay. We've talked about that. So retroactive, let's talk about that one here, okay? Well, first of all, Sometimes an employee has a serious health condition, but they don't know that it's a serious health condition until they find out later on. And so the time that they took off originally, it turns out that it was actually within the parameters of that. So that would be an example where they apply it retroactively. But more typically, what I see retroactive is that at the time that I initially go out on FMLA, on what turns out to be FMLA, I don't know that it's FMLA. I don't know that it's a serious health condition. And then later on, I find that out. And so therefore, the time begins not when I tell my employer, and I haven't come back to work yet, okay? But it's back day one when I didn't report to work. That's day one, okay? That would be an example where it doesn't cause harm. All right, so let's talk about the next slide. Maintain group health insurance, in that you have to tell them what's going to happen here and how this is going to be occurring. This is really, I think, the Pandora's box of FMLA, is that assuming that neither the employer or the employee know about FMLA, well, they have to hire them back. They also have to give them the same terms and conditions. And this could be problematic because the group health plan, it's a third-party administrator. And can you get them back to what existed at the time that they first went on the FMLA leave? Okay, so that's the reason why it's important to make a determination as to whether or not it is or is not FMLA right up front from the get-go, because you have to offer them the same terms and conditions that would otherwise be applicable to them. Okay, now in the next slide, where we talk about while they're on FMLA leave, the employee still has to continue to make arrangements with the employer as to how their premiums are going to be paid. If the employee chooses to not retain coverage, when they come back, you still have the obligation to restore back to the coverage that they could. So they could re-get the insurance there, okay? Sometimes an employer will simply pay the employee share of the premium, but there's no pay being paid to deduct it from. So they would tell them in the upfront notice about how they will make arrangements so upon their return and how it will be paid back. Okay. Now, in the next slide, where we talk about job restoration, that's the whole point of FMLA. Give them back the job that they had, same pay, same conditions, same benefits. The employees don't have any greater rights under FMLA when they would normally have. So if, for example, at a manufacturing facility and they eliminate the third shift and I worked a third shift, well, if I would have been already lost my job anyhow, they don't have an obligation to find them work when they come back. The burden of proof is on the employer, and where it would get really suspect, where we'd look at it close, if only one person and their job's been restructured or reclassified and they've now been obsolete. Well, was that going on before they applied for FMLA? Or is this just a smokescreen for FMLA? Okay, so the burden of proof is on the employer on that one, but they don't have any greater rights. Bonuses, if they're based on achieving certain predetermined goals and they're on FMLA, well, then, and they don't get those goals, well, then they don't get the bonuses, nor do they have a right for that. The key employee, and that would be in the next slide here. No, I'm sorry. Let's talk about key employee. A key employee is a person who is in management in the top 10%. And they're, when I say top 10%, salaried employee, okay? In the top 10% salaried employee, and they're in management. And the employer is in a position where they need to hire a replacement, but they can't find a replacement if they know it's only going to be temporary and then they're going to be let go as soon as this employee returns. The employer cannot deny the taking of the FMLA, but they can deny job restoration. They need to be told this, the person taking the FMLA, in their notice that's given to them of the potential of not having job restored back to them. And the reason why the employee may still proceed, because under FMLA, they still get the insurance coverage under that, okay? So I have here about key employees, and that's in 825.219, okay? In the next slide here, prohibited acts. this is where we're talking about discriminatory practices of an employer. You cannot make it overly burdensome for the employee to invoke their rights under FMLA. And when we talk about discriminatory acts, we're talking about the employer or through their agents. That could be an immediate supervisor who they're upset with the employee for not being there, and therefore it's placing everybody on their team, and they take retaliatory actions against them. Or they place unrealistic or burdensome rules on them. And particularly if they place a rule that is not permissible under FMLA, such as requiring that they go to the doctor every time that they take time off for FMLA. Well, depends upon the FMLA leave. But typically that's not, or requiring recertification. They can't do that unless it's more than every 30 days. Discriminate or retaliate against an employee for exercising that would be where they're denied, well, one, denied the job, but also they could be denied certain benefits that they would otherwise be eligible for, okay? And in upcoming performance reviews, evaluation, the FMLA absences cannot be counted against the employee. And that's what that next one there is talking about. Okay, maintain records, the next slide. On this one here, on maintaining records, there is no prescribed records, it's just that you have to have records about it, okay? When does the FMLA, and these are the factors that you need to be tracking, but how you track it, that's not prescribed by the law itself, okay? And I'm told by employers that there is software out there that they've used in helping them track the FMLA usage. And I can't promote any one of these, okay? Records are your friends, okay? So they can close the door in case there is a misunderstanding that occurs with the employee. Well, if you have the records to back it up, you can first show it to the employee, and if they still file a complaint with the Department of Labor, then you'd be showing it to the Department of Labor, okay? Now, in the next one, employee responsibilities. Employees, when they apply, just because the employee thinks that they have a serious health condition doesn't necessarily make it so. So they need to comply within the protocols of the employer. So as far as calling in procedures and policies, they need to do that. If the employer, the certification, they need to return it within 15 days, absent any extenuating circumstances. If you require a periodic status reports, okay, but tell them that. And the reason why you might require periodic status reports would be once an employee gives a declared intent of not going to return to work, their FMLA job protection cease at that point there. Okay, so let's go on to the next slide. Notice requirements. On this one here, the employee, this is the employee, what they need to tell you, okay? But as soon as they know, and as we talked about earlier, as far as if it's a foreseeable event, they have to tell you at least 30 days in advance. And if it's intermittent leave, they have to try to schedule it so that it accommodates to the employer's needs, okay? So now in the next slide, timing, well, we talked about that. So let's just go right on to the next. And when I say as soon as possible, that means obviously if the employee's in the hospital and they cannot talk and a spouse calls in, that should be sufficient, okay? Provide certification, okay? This one here, you've made a preliminary determination that they're eligible. You notify them of their eligibility as well as their rights and responsibilities. You provide them with the certification that needs to be completed. They need to return that certification to you within 15 calendar days, absence extenuating circumstances beyond the control of the employee. If what is returned to you is deficient, if it's not completed, if there are things left blank, and it's not, you can't make a determination then you have to, before you just deny the certification, you have to give the employee an opportunity to remedy that, to fix it, okay? And the annual certification, you may require that on an annual basis, okay? So going on to the next one, the employee pays for the first one as far as that one. The employer, a representative of the employer may contact the healthcare provider to authenticate, one, is it really you, and to seek clarity. But the employee's direct supervisor cannot talk to that. And that's, if you think about HIPAA, but it's to prevent that flow of information that could inadvertently compromise the confidentiality of the applicant, of the FMLA person. Sometimes a second and third opinion, the employer wants a second or third opinion, you may do so. The second opinion is at the cost of the employer. So too is the third opinion, but also the third opinion is binding. So the first opinion says one, second opinion says something contrary to that. You mutually agree on a third party, and that's who you go for, the third party. Okay. So in the next slide here, provide recertification. You cannot do that more frequently than every 30 days from when and absent. You can't just have a standing rule of every 30 days, okay? Well, this is where you could, I guess, if the conditions themselves change, or if you had reason to believe that there was fraud occurring, okay? Okay, now in the next slide here, fitness for, I'm sorry, we talked about that, so let's just go right on. And I'm looking at the clock, that's why I'm talking really fast here. So fitness for duty certification, if you're going to do it, tell them. And there are jobs that you would do that, for example, lifting capacities, etc. Okay. Other issues involved, the next slide here would be with exempt employees, exempt 541 executive administrative professional that have a salary requirement, you may make a deduction from their wages without losing the salary criterion of that exemption. They remain exempt, all right? If you're using a fluctuating work week method, which very few people do. And the special rule for schools is that with salaried employees, teachers are paid on salary, there are 2 months of the summer they're off, so that 2 months doesn't count against them, even though they're still getting the salary, okay? And now we talked about the next slides are going to be about the military. And I'm just gonna, you know what? I'm just gonna, unless somebody has a question about that, we're gonna run all the way through to slide number 75. If you would, Todd, just jump forward to slide 75. And again, I'm keeping track of time, and good guests arrive on time and they leave on time, okay? And I want to be respectful of your time, and thank you very much. We so appreciate it. Enforcement mechanisms. Now under FMLA, they can file a complaint with the Department of Labor, but they're not obligated to file a complaint with the Department of Labor. They may file their own private action civil suit. Sometimes when you see private action civil suit is when you're going to see liquidated damages that I referred to earlier. And there is a statute of limitations of 2 years. And if it's proved to be willful, 3 years. So it's the same statute of limitations that you see under the FLSA. And the last slide here is where would you find material on that? And that's also here, the back here, FMLA forms, FMLA fact sheets, and you can see, and I've hyperlinked where I could. And then the very end where you would find additional information would be on our website itself, which I provided you with that hyperlink. Now it's straight up at 129. Is there any question in the box that hasn't been answered?
There's one that just popped up several years ago when we had a policy for fitness for duty upon return to their job. So when their family doctor released them to work, we would have them perform a CRT, strength and agility computerized test. But we're told we're not able to do so to challenge their family's doctor's release. Is it okay to require the company's fitness for duty?
If they applied that uniformly and they did that to people who's not on FMLA, who were on a leave of absence, I'm not seeing that as being discriminatory. I would think that the reason why you were told that was somebody was saying it's better to play it safe than sorry, and that potentially somebody could argue that you are discouraging a person from using this because you're requiring this fitness for duty. But I can see a very real scenario where I'm a hospital worker and I need to be able to lift 40 pounds because if a patient falls, I need to be able to catch them. And so you're testing to see, can they in fact lift 40 pounds because my eyes are telling me something different than that. So it would be fact pattern driven, but it's not at face value a violation of FMLA. And it potentially could be, but not at face value. Any other questions?
Those were the questions in the chat. I have a couple of folks coming in saying thank you.
Well, thank you. And I'll stay online if somebody has some non-FMLA related questions about the Fair Labor Standards Act, for example, or any other of the laws that we enforce, because I am a public servant. I am here to serve, and I am so grateful that you allowed me to have this opportunity to engage in dialogue and compliance. That's what we're about, compliance with the federal standards. And for the rest of you, thanks so much for your time. I really appreciate you taking the time out of your busy day, or as the case may be, during your lunchtime. Thank you very much.
Yeah, well, it looks like a couple comments come in. There just a lot of thank yous and great info. See if any questions pop up here in the next minute. As a reminder to everyone as well, the SHRM and HRCI credits were posted at the beginning of the meeting. I'll post them again, so they'll be in the chat if you'd like to snag those and receive your credits for attending the event today. Well, it looks like that's the last one coming in, Tom. Oh, looks like there's. Okay, so one of the questions is.
Yes, it could. Fetus could be a qualifying reason, definitely. Because if left untreated, it can cause serious health issues. And I would assume that the intermittent leave was for doctor's appointments. But I could also potentially hypothesize I'm having a flare-up. I don't know that much about diabetes. I'm sorry.
Perfect. The other question by Angela, we'll send an email out with instructions on how to redeem the SHRM and HRCI codes to the participants. We'll send the codes out, and as well as a link to the recording of this video and the PowerPoint presentation too for your reference. We're able to see the next question there, Tom, in the chat.
Diabetic issue allowed them to call in while adjusting the medication. No, Dr. Swain. That sounds familiar to me. Can you explain the rolling 12-month again? Okay, so let's just say I take FMLA. Today is May 17th. That's day one. Okay, so for the next 12, so do I exhaust 12 weeks up to May 16th of 2023? But by May 20th of 2023, the 2 days that I took off on the 17th and 18th drop off. So it just rolls. That's how 9 out of 10 employers do it.
Awesome. Well, great questions. Greg, if you're on the line too, are there more folks in the meeting still that might be asking questions, or a lot of folks taking off?
There are a few attendees left, but I think it looks like all the questions have started to filter through.
Perfect.
We do have a wage hour investigator on phone duty every single day, Monday through Friday, from 8 a.m. to 4:30. Our agency has made a purposeful managerial decision to have live human beings answering the phone. And we've really been throwing the resources at that. So for example, when we had the Family First Coronavirus Response Act, everybody's on the phone. So because there was such an influx of call, but sometimes they'll put out a call of action. We need more people on the phone so that phone calls get answered. If it happens that you don't get a live person answering the phone and you leave a voicemail, we want those returned promptly. I mean, within that day for sure, but as soon as possible. And again, they put the resources to do this because the laws that we enforce are simply too complicated and there are too many nuances for us to ever come up with some type of automated system. The automated system is simply an opportunity to leave a voice message so that the person can call you back. Okay. And we posted the number at the very end there, the national number. Or you can look online and you can call the local wage hour office to you, which is on our website, the main website, which I provided a hyperlink to.
Thank you for that. If there are no more questions coming through the chat, we will conclude today's webinar presentation.
Thank you very much.
Great.
Sure do appreciate it, y'all.
Yeah, thanks for coming out, Tom, and talking with our group. I know they appreciated it. A lot of questions, a lot of attendees. Thanks for your time today, and we'll shoot you other any questions if folks have some coming in later through email.
Sure. Okay, that'd be great. And you have my email address. Thanks so very much.
Thanks, Tom.
All
Thanks
right,
everyone who
bye, y'all.
participated.